Good morning. See, when you are dealing with the cases under Special Act, you should be very careful in filing appeals or revision, whatever it may be, because if that contains a specific provision for limitation. You cannot invoke Section 5 Limitation Act, and there is every possibility of your not entering into appeal and getting justice on technical ground. For that, you should be very careful. Even appeal against the acquittal, the provision itself contains limitations. So you may not be in a position to get over that limitation. Like that, so many other provisions are there in Special Act, barring limitation, restricting limitation, and preventing you from applying Section 5 Limitation Act. So for that, I refer the judgment AR 2025, AR 2025 657, AR 2025 Supreme Court 657. This is My Preferred Transformation and Hospitality Private Limited versus Faridabad Implement Private Limited Company. Therein, they have categorically discussed Arbitration Conciliation Act Section 34(3), prescribing limitation, 43(1) limitation, and Section 4 and 29(2) of the Limitation Act, and Section 10 of General Classes Act. After discussing all, despite there was a 3 months period prescribed for filing petition expired on 14/5/2022, but that period was extended up to 29/5/2022. So, but however, he could not file it. He only filed on 4/7/2022, the opening day. But when his period expired, at that time the courts are not closed. Therefore, unfortunately, he lost this case. But however, there was the division bench judgment. Padimangandam Sri Narayana has categorically held and said the dismissal of appeal is right. But the other judge has given suggestion to legislation, union government, to look into revisit these provisions because on simple technical grounds one cannot be denied justice on appeal where he is having other good grounds too and a very good causes to get a delay in preparing appeal being condoned. For all this purpose, the judgment is very helpful to you. Best wishes.